The Supreme Court just issued an emergency ruling that could drastically alter how gun permits are handled nationwide.
The requirement for a pistol permit is once again in the spotlight for Alabama lawmakers. For those stuck waiting on approvals, that process might soon be obsolete.
What's catching everyone off guard is that the Department of Justice isn't pushing back. They're actually supporting the shift. 26 states are now backing this change, while states with strict permit systems are rushing to defend their laws. This isn't just another court case. It has the potential to completely reshape how the right to carry is viewed across all 50 states. This could be the most significant Second Amendment moment since the Bruin decision, and the effects are already being felt. Disclaimer: I'm not an attorney, and this isn't legal counsel. Firearm statutes shift quickly and vary by zip code. Always consult a licensed lawyer and your local ordinances before acting. How Hawaii tried to sidestep the Supreme Court. This case didn't happen by chance. It exploded because of Hawaii's response to the Supreme Court's 2022 Bruin ruling. That decision made it clear states can't manipulate carry permits like a privilege. The Constitution doesn't require citizens to prove they deserve a right. It assumes the right already exists. But Hawaii ignored that message. Instead of loosening restrictions, they doubled down and created something even more extreme. They flipped the entire concept of public carry on its head. Under Hawaii's new law, you couldn't carry a firearm on private property unless the owner gave you written permission in advance. No verbal okay, no posted sign, just a prior written agreement. If you didn't have it, you were breaking the law simply by entering. And this wasn't an oversight, it was intentional. The law weaponized silence. It turned everyday activities, going to the store, filling up gas, grabbing coffee, into potential crimes. Malls, parking lots, restaurants, all off limits unless the owner had explicitly allowed firearms in writing. This wasn't regulation, it was a trap. And Hawaii wasn't alone. California, New York, New Jersey, Maryland, and Massachusetts all followed the same playbook. Instead of easing permit rules after Bruin, they tightened them. Between 2022 and 2024, those 5 states passed 47 new gun control laws combined. Hawaii led with 14 of its own. But one law went too far. It made 99.8% of private property off limits by default, unless you had written permission. That includes nearly every place people visit daily. Even the Ninth Circuit struggled to justify it, and when lower courts upheld it, the Supreme Court had to step in. Hawaii's defense: a single, weak historical reference from the 1800s that had nothing to do with carry permits. That was it, and it wasn't enough. But the real shock came when the Department of Justice switched sides. The DOJ flipped, and it changed everything. What happened next is almost unheard of. The DOJ publicly reversed its position in a major Second Amendment case, and did so forcefully. Typically, when states enact strict gun laws, the DOJ defends them, citing public safety or historical precedent. But when Hawaii's law reached the Supreme Court, the DOJ took a hard look and said, "We can't support this." They told the court the law wasn't about protecting property rights, it was about blocking carry rights through a permission system with no legal or historical basis. The DOJ noted that trespass laws already give property owners control. So, why the need for a default ban? The answer: restriction, not protection. In their brief, the DOJ used the word pretextual 4 times, legal language for "this is a cover." Then, in a rare move, they asked to speak during oral arguments, not to defend Hawaii, but to support the challengers. This is only the 3rd time in 40 years the federal government has flipped sides in a Second Amendment case. That's how serious this is. Once the DOJ moved, the tide turned. State attorneys general shifted strategies. Then 26 states filed briefs supporting the challenge. Not a handful, over half the country. This wasn't just support, it was a warning to every state with a similar system. And if the court strikes down Hawaii's model, the fallout won't stop there. How Hawaii made silence a crime. The core of this case rests on one quiet but dangerous idea. Hawaii didn't just pass a law, they redefined permission in a way most people wouldn't notice until it was too late. Instead of saying you can carry unless told otherwise, they said you can't carry unless explicitly approved in writing. No sign, no conversation, no warning. If the property owner said nothing, you were automatically breaking the law. Imagine being a lawful gun owner. You passed your background check, paid your fees, took your training, got your permit. You walk into a grocery store, no signs, no issues. But under Hawaii's law, you're committing a crime. Why? Because the store didn't give you written permission, and you had no way of knowing. Even worse, lawmakers expected this. Internal emails revealed they counted on businesses not posting welcome signs. Their own attorney general admitted less than 0.5% of businesses would ever post approval. The silence was the plan. It turned everyday life into a legal trap. This flies in the face of Bruin, which said your right to carry is the default. Restrictions must be narrow, justified, and historically grounded. Hawaii did the opposite. They made restriction the default and silence the crime. Even the Ninth Circuit, known for upholding strict gun laws, could only cite two weak examples from the 1860s, both already rejected by other courts. Hawaii didn't just push the line, they crossed it. Why this should worry every American. Here's the bigger picture. If Hawaii can quietly rewrite how the Second Amendment works, what's stopping them from doing the same to the First or Fourth? If they can turn a right into a request, what's next? That's the question the Supreme Court is about to answer, and the impact won't be limited to Hawaii. The legal shockwave is already spreading. The legal domino effect has begun. The moment the Supreme Court took this case, everything shifted. What was once a state-level issue is now a national legal earthquake. If the court rules Hawaii's law unconstitutional, it won't just affect the islands. It will topple every similar system across the country. California, New York, New Jersey, Maryland, Illinois, Massachusetts all built copycat systems. All hoped to dodge Bruin by hiding behind technicalities. But once Hawaii's model falls, their cover is gone. Right now, 127 federal lawsuits are on hold, all challenging state-level carry restrictions. These cases are waiting for this ruling. Lawyers have paused, judges have delayed, states have stalled. But once the decision drops, those cases will activate all at once. Courts will be forced to apply the new precedent. States will scramble to rewrite laws, and some are already retreating. New York quietly shelved 3 major gun restrictions after internal memos warned they wouldn't survive. California paused 2 new permit rules scheduled to launch months ago. New Jersey's Attorney General told prosecutors to use discretion on permit violations. Legal speak for don't enforce this unless you want to lose. These aren't minor tweaks. These are preemptive surrenders. The states know what's coming, and they're bracing for impact. The financial collapse no one saw coming. There's another crisis brewing, and it's not constitutional, it's financial. For years, permit systems weren't just about regulation, they were revenue machines. States collected hundreds of millions by making people pay to exercise a right. In 2023 alone, California made $47 million from permit fees. New York took in $39 million. Illinois added $29 million. Across permit-heavy states, that's over $200 million per year, just in government fees. And the private training industry, even bigger. Mandatory carry courses generate $680 million annually. Ranges, instructors, certs, software, the whole ecosystem. But when permits become optional, that money vanishes, and the collapse is already happening. Hawaii's permit division cut 2 to 3 of its staff after applications dropped 75%. New York refunded $7 million after courts blocked training rules. California suspended its $100 issuance fee after losing $1 million month. New Jersey is projecting a $41 million budget hole. Illinois expects to lose $33 million. These aren't projections. They're layoffs, closed offices, canceled contracts, and the private sector is just as bad. 3 major training companies filed for bankruptcy between late 2024 and early 2025, all citing the same reason, the end of mandatory training. When a right becomes a business model, that business depends on restriction. Now that the courts are clearing the path, the whole system is crumbling. Police and prosecutors are caught in the middle. The first real-world fallout didn't hit lawmakers, it hit law enforcement. Sheriffs, police chiefs, and prosecutors are now stuck between state laws and a Supreme Court ruling that could strike them down any day. By January 2025, the uncertainty broke. 19 California sheriffs publicly announced they would no longer check for carry permits during routine stops unless another crime was involved. Their reason? We can't enforce a law that might be declared unconstitutional in weeks. These weren't activists. They were elected officers trying to avoid lawsuit. A 2024 survey found 2/3 of police chiefs had already told officers to use discretion on permit violation, meaning don't enforce unless it's dangerous. Officers were told to stand down not to defy the law, but to avoid liability if it's later overturned. Prosecutors made the same call. Between mid-2024 and early 2025, 14 counties dismissed over 1,800 charges tied only to permit paperwork, not violence or illegal possession, just missing document. And they're dropping them because they know if the court rules against Hawaii, every one of those convictions becomes a lawsuit. Even gun control groups are in crisis mode. Every town held emergency strategy calls in early 2025. Leaked memos show them rebuilding their legal framework from scratch, not to expand, but to survive. Gifford's Law Center pulled millions from lobbying and shifted it to litigation defense. This isn't just a court case anymore. It's a reckoning over who holds power, the government or the people. Who holds the power, you or the state? At the heart of this case is a question bigger than permits. Does your right to carry start with you, or only exist if the government says yes? If the court rules the right begins with the citizen, then every system built on permission first collapses. For decades, states treated carry like a privilege, not a right. Bruin rejected that. The Second Amendment deserves the same protection as the First and Fourth. Hawaii didn't just ignore that. They built a system where silence equaled denial. You had no right to carry on private property unless someone gave you written approval, not because you were dangerous, just because you didn't have a note. Imagine needing written permission to speak in a store, or police searching your home unless you handed them a letter saying no. That's how Hawaii treated the Second Amendment. Bruin's test is simple. If a restriction didn't exist at the founding, it probably doesn't belong now. And no historical example supports Hawaii's blanket permission system. The closest, an 1870 Tennessee law, was struck down by its own Supreme Court a year later. Hawaii tried to hide behind property rights, but there's a difference between allowing owners to say no and forcing them to say yes or else. One respects freedom, the other erases it by default. The court is about to draw that line, and once it does, it will echo through every law, every courtroom, every state. What America looks like without permits. So, what happens if permits disappear? What does a permitless America actually look like? We already know. 29 states now allow constitutional carry. Between 2010 and 2024, 21 states dropped their permit requirements. Critics warned of blood in the streets. The data says otherwise. FBI stats show violent crime fell 8.2% in constitutional carry states within 3 years. In permit-required states, just 2.1%. Vermont never required a permit and consistently ranks among the safest states. Maine went permitless in 2015. A decade later, their firearm homicide rate is 1.1 per 100,000, lower than before. New Hampshire, 2017, and South Dakota, 2019, saw no spike in violence. Why? Because permitless carry doesn't help criminals. It removes hurdles from responsible people. The ones breaking laws never applied for permits anyway. This shift cuts red tape, fees, classes, wait times, renewals. It doesn't remove responsibility. It returns it to the individual. Some states will go fully permitless. Others may keep optional permits for reciprocity. Training will shift from mandatory government programs to voluntary education, which many gun owners already seek out. The court's ruling won't create a uniform policy, but it will set a constitutional floor. You can't treat a right like a privilege. Expect an 18 to 36 month transition as laws are rewritten, courts adapt, and agencies adjust. Some states will move fast. Others will resist until lawsuits drag them forward, but the direction is set. Final word. Here's where we are. A Supreme Court ready to redefine the Second Amendment. States scrambling to rewrite laws that were never built to last. A permit system that's out of time and out of excuses. The system is cracking, the court is closing in, and the Constitution is about to have the final say. Make sure you subscribe to Weapons Law Advisor. And don't forget to like and comment on the video to help us reach our amazing milestone of 10,000 subscribers. Every single subscriber matters. Your support is what makes this journey possible.